A, all persons having anything to do before the Honorable, the Justice of the Appeals Court, now sitting at Boston, within for the Commonwealth. Draw near, give attendance, and you shall be heard. Now see the Commonwealth of Massachusetts, court is open, please be seated.
Thank you.
Okay, good morning and welcome to today's sitting of the Appeals Court. We're pleased that you all got here safely. I will remind everybody in the courtroom that you have 15 minutes to present your argument. We've read the briefs, we've read everything else you've submitted to us. We're familiar with the transcript of the trials, and so you can get right to your most important points when you get up into the podium. Your panel today consists of, on my right, Justice Robert Brennan, to my left, Justice Andrew D'Angelo, and my name is Ariane Vuno. All that said, the first case is Commonwealth versus Alexander Morales, 2024-0730. Good morning.
Good morning, Your Honors. May it please the Court. Kevin DeMello on behalf of the appellant defendant, Alexander Benitez Morales. Your Honors, in this case, there were 3 other people in the apartment. There was nothing to connect Mr. Benitez to the gun beyond the mere knowledge of it he expressed during the recorded interrogation. And based on that, the Commonwealth failed to prove that he constructively possessed that gun. If we find that his statement is admissible, you would agree that that would make the evidence sufficient, wouldn't you? I actually don't, Your Honor. In reviewing this case, it struck me that, and in talking about it with some of my colleagues and showing them the video, it struck me that the constructive possession argument is actually the strongest argument here because there are some serious problems with this video. I'll jump right to it. He obviously talks about a gun in the video. But it's so hard to understand exactly what he's saying and exactly what that conversation is that it might prove knowledge, but in order to get to constructive possession, you have to prove the intent to possess, the intent to
exercise
dominion and control.
Okay.
Sorry.
So let me ask you, if I could, about the video. So it seems to me we have 3 possibilities. Either the video is what the Commonwealth says it is, and if so, it's probative and highly probative, right?
Right.
Option 2 is it's not what the Commonwealth says it is, and to the contrary, it's exculpatory, in which case juries should still be able to hear it if they can figure it out. Option 3 is you can't figure out what he's saying, in which case it seems to me it's a wash, and it's neither probative nor prejudicial. So why not give it to the jury and see if the jurors can figure out what the man is saying?
So this gets into the argument that it should have been excluded, right. Which, I think is a slightly weaker argument, but okay. I think to understand here, the prejudice comes not necessarily from the video itself, because I agree with the trial judge. You watch the video, it really isn't very probative, and that's kind of what I'm getting at in my first argument. I don't think this proves the case. That said, the prosecutor made it pretty prejudicial. She argued both in the motion in limine to exclude it, or he argued both in the motion in limine to exclude it, his opening and his closing, that this video proved that this man had the intent to exercise dominion and control. By doing so, the prosecutor invited the jury to speculate on what this video meant, because it doesn't say that.
Let's assume the video was excluded for a second. Wouldn't the police officer be allowed to testify to what he thought the defendant said based on being present at that scene?
Right, so actually I think the case law is pretty clear that typically a police officer can testify to his conversations with defendants. It's offered against a party opponent. That being said, that rule is still subject to the substantially more prejudicial than probative standard. And in this case, I'd argue that his testimony, first of all, we do have the video in evidence.
My hypothetical was that if it was excluded, though.
Sure,
so
let me focus on the hypothetical.
Would you have wanted just the officer's testimony? Because that was pretty inculpatory, wasn't it?
It was, and I would have argued that the officer's testimony shouldn't have come in based on the video, because the video does, well, let me back up a little bit and say this recorded interrogation was highly problematic. There was clearly a language barrier here, and there was real questions about whether this officer understood what this guy was saying and whether my client understood what the officer was asking.
I'm going to ask a rhetorical question about that, which is there was no motion to suppress, correct?
Correct.
On the statement, nor was there a motion for new trial where ineffective assistance for failing to file a motion to suppress was raised, correct?
Correct.
Okay. So you want us to dig in and try and figure out what might have come out during the course of a motion to suppress evidence, evidentiary issues, credibility issues?
I certainly understand the court's difficulty with that. I mean, I argued in my brief, and I'll restate it now, that, I think the record is sufficient. You've got the whole Miranda reading of the rights. It's in the recorded interrogation. You've got the defendant testifying about the recorded interrogation. Now, he says he doesn't remember much, but I mean, he's not going to, if he doesn't remember much, he doesn't remember much. You're not going to get anything more out of him by, having another hearing. And you also have the officer testifying about what he did. So there is a record here, if the court's inclined to look into that. And I think, I understand it's a difficult argument, and I raised it because just looking at this case, it raises some serious questions about, the police procedure that was used here. You've got an officer who clearly had a language barrier. Why didn't he?
You keep saying that, counsel, and I guess I want to separate what Justice Brennan just asked you about on a motion to suppress. There's not a lot of evidence that your client didn't understand English very well. The officer said he had trouble understanding him, but I think an inference from that is, I had trouble, but I still understood him because, so at least on that basis, Justice Brennan is absolutely correct. What evidence is there about the understanding of English that we could grasp onto? Voluntariness might be a separate issue, which we'll get to in a moment. But what evidence is there about the language barrier being so bad that it wasn't a valid waiver?
So, first of all, I'd point out that just because the defendant's answering questions doesn't mean that he's understanding what's being asked. And, we've all watched the video. It's disjointed, it's difficult to understand, it's difficult to and the people in this, the officer's saying he has a thick accent, sometimes he's hard to understand. The judge is saying...
Let's just be clear, we only saw a clip of the interrogation.
Correct. The entire interrogation is like 50 minutes, and the clip that was offered was about 3 minutes or something.
Exactly.
Right. I'm not sure that watching the entire interrogation would be very helpful. I've watched it, but in any case, it's not in the record. But, again, I'd argue that in viewing what's in the record, and also the fact that, there's a Spanish interpreter that's used at trial, the officer's characterization of he's difficult to understand, thick accent, I mean, all of that suggests that there's a real problem here. And that perhaps the judge should have seen this. The trial judge should have seen that there was an issue and brought it up. I did cite the Harris case, which references a sua sponte duty on the judge to analyze, whether a confession's voluntary. Again, in my brief, I'm not sure it's entirely on point, but,
So voluntariness, yes, but what about Miranda? So those are distinct
They're
concepts.
distinct, and
Right.
what I'm trying to argue is that a waiver of Miranda has to be voluntary, has to be knowing and voluntary. And to that extent, maybe the judge should have a duty to see, is this a voluntary waiver?
So the language issue, under your argument, goes to the voluntariness as opposed to the knowing and intelligent?
Well, I think it's both. I think...
Do you have any case that says that?
I don't have a case that says it in terms of Miranda. I cited the Harris case, which talks about specifically a voluntary statement. And that was really specifically cited to highlight the fact that the judge should have been flagged to this, should have had a duty to look at this.
All right, let's now that you're on the voluntariness issue, let's get to that. Your client, again, even though broken English, there's testimony that he was under the influence of drugs, and he testifies that he doesn't remember certain things. In your reply brief, primarily, you suggest that that raises a live issue of voluntariness. Is that correct?
Correct, Your Honor.
Counsel never asked for any voir dire. He never asked for a humane practice instruction. So what should we do, whether it's actually a live issue, if the lawyer didn't bring it up and the judge certainly didn't bring it up on her own?
Well, on that issue, I'd say Harris is on point. It is something that the judge had a duty to bring up, and if the judge failed to do so, this court has the ability to analyze that. And the Harris case did that. And I think that's something that should be looked at in this case. And again, I think, taking a step back and looking at the broader picture here, this case presents some serious issues, and it should be very seriously scrutinized as to how this recorded interrogation was used in this case. And it kind of goes back to the primary issue, which is, is this sufficient evidence of constructive possession? You've got this video, and I've listened to it so many times, and you pick up words here and there, but the words that you don't pick up can change the meaning entirely. Like he's talking about, I make people touch the gun, or something along those lines. But if the words before that are really hard to make out are, he said, I make people touch the gun, that completely changes the meaning of the thing. So I just think that this evidence, this recorded interrogation, it's not sufficient. It's so ambiguous that it's not sufficient to prove that knowledge element, that intent to exercise dominion and control.
But again, the jury was not left with only the recorded video. They also had the testimony of the police officer.
They also have the testimony of the police officer, but the police officer's sole knowledge that he's testifying from is based on that recorded interrogation. That's pretty clear from the transcript. If you look at the transcript starting on page about 170 of the first volume, that testimony...
Then in that respect, you're saying that the video could actually be used to sort of somewhat impeach the testimony of the officer.
Absolutely. I think, in fact, the video kind of
the
negates what the officer says, because the officer says, yeah, he's saying he's going to get a new gun, but then you listen to the video, you've watched the video, and you're like, well, does it say that?
So doesn't that help you?
It does help me, which, again, I think goes back to the first argument, why I think it's a strong argument. Even if all this evidence comes in, it's not enough. It's not enough to...
So why are those not jury questions? What to weigh, what to credit, how much weight to give the testimony of the officer as opposed to the video? And if we're taking it in the light most favorable to the Commonwealth, right, and draw all the inferences in the Commonwealth's favor, couldn't a rational juror have landed where this jury landed?
So our position is that no rational juror, based on this evidence, could find constructive possession. Okay. Maybe a rational juror could find that this guy knew about the gun. But in this broader situation where you've got 3 people in the house, the only thing is this recorded interrogation, and he's...
Even if the jurors say, well, we can't make heads or tails nor tails of this recording, so what did the officer say? And they just go solely on what the officer testified about and take that as the evidence.
But the problem with that is the officer's testimony is what happened in the recorded interrogation. So if the officer's testimony says something that's not in the recorded interrogation, how can that be competent evidence on which you can base a conviction? It doesn't seem fair to the defendant.
That's not for you to decide. That would be for the jury to decide.
Well, Your Honors, respectfully, I think it's for you to decide if this is competent evidence.
Actually, no. In other words, I think your point right now is that the officer's testimony is based on a video, and you're saying the video does not support the officer's testimony only because the video can't be understood. Is that right?
Correct.
Because at one point the defendant says how the gun doesn't work and how it doesn't come back, and the officer's talking to him about that, and that's exactly what the officer testifies to at trial. Says that the defendant says that the gun didn't work, that it was stuck, etc. Right?
Right.
So that...
So this gets into almost, I didn't cite this case, a Commonwealth versus Pleas argument. That's the case that talks about when an officer or a witness can testify about an identification in a video and whether that witness is in a better place than the jury to see what happened in the video. Mm-hmm. And so this is kind of a similar thing. You've got an officer who's testifying about what happened in a recorded interview that we have, but is he in any better place than the jury to figure out what that recorded interview says?
But your argument is that the video shouldn't be admitted.
Right.
So I guess I know this seems circular, and I apologize, but it goes back to what I said at the beginning, which is if the video had been excluded, the only basis you have to exclude the officer's testimony is that it's prejudicial. It's pretty probative. If you don't have the video in, the only evidence of what the defendant said in that police interrogation room is what the officer would testify to. That puts it pretty high on the probative scale. So your argument about prejudicial, probably not a good one.
Right. So first of all, I'm trying to argue in the alternative, right? But secondly, at trial, I would have argued that that officer should not have been allowed to testify to that, even if the video doesn't come in, because judge, look at this video. How could, this is the source of his knowledge. How could he possibly be able to testify to this?
Okay. Well.
If there are no other questions, Your Honors, then I will rest on my brief.
Thank you very much.
Good morning. May it please the court. Danielle Borges on behalf of the Commonwealth. The Commonwealth respectfully asks this court to affirm the defendant's conviction of carrying a firearm without a license. I'll start briefly with the sufficient evidence of constructive possession, as we were just discussing that. As was being discussed, it's the Commonwealth's position that, viewing the evidence in the light most favorable to the Commonwealth, the jury heard sufficient evidence that the police were given consent to search the apartment. During the search, they found the firearm under a drop ceiling tile, and they later heard through the testimony and the recorded video that when Detective Sergeant Bellafato interviewed the defendant, he explained, several things. He did not live at 186 Pritchard Street. He visits there. He explained he knew the firearm existed, believed the firearm was broken because it was stuck back, and he was basically working at getting another one from where he got that one from. So yes, while it wasn't a clear as day video, the jury still heard the officer's testimony and saw the video, and therefore it's the position of the Commonwealth that the evidence was sufficient to prove beyond a reasonable doubt that when the firearm was found in the ceiling where the defendant visited and slept, the defendant knew of the firearm, had the ability and intention to exercise control over it.
Can we jump a little ahead?
Sure.
Why wasn't it incumbent upon the judge here to give a humane practice instruction, or at least address in some way the voluntariness of the statement?
In regard to the Miranda waiver?
Not the Miranda waiver.
Just the statement.
Yeah, just the statement. Voluntariness says, again, humane practice, which is always an issue, which is, regardless of whether it was a motion to suppress, is something that the jury has to accept before accepting the defendant's statements, or has to find, I should say.
It would be the Commonwealth's position that the judge, after watching the video, made the determination that it was not prejudicial. In fact, she said, she didn't, as discussed, she didn't think it added a ton of value, and I think that was within her discretion to, first, the instruction was never requested, but again, it was within her discretion to not give it where
Putting aside the video, the officer testified about it. You're saying that voluntariness was not a live issue in this case at all?
The Commonwealth's position is that it was not a live issue in this case, where the testimony of the officer, there was nothing there that would have supported an argument that the...
What about the sum of all of the evidence, which would include the defendant's testimony that I really don't remember a whole lot, and I was taking drugs? And you woke in a bit of a stupor, if you will. Why doesn't that at least raise the issue on some level?
I would say it was just within her discretion to not give it, where I guess then it would come down to a question of whether the jury weighs the statement of the defendant versus the statement of the officer.
You familiar with a Worcester County case called Commonwealth versus Bohigian?
Yes.
In that case, was not an issue raised by defense counsel, was not an issue raised by the trial judge, and yet the SJC said it was a live issue because he had hit his head against the windshield, and therefore the judge sua sponte should have, A, considered it, and perhaps more importantly to Justice Bredin, B, let the jury decide it and give a voluntariness instruction.
That's true. I would think in that case, distinguishing it from this one, the severity of the concern was a bit more than this case, but I can see the comparison.
Can I ask you about the police officer's testimony? There's a couple of times during the police officer's testimony where he says he believed what the defendant said was X, Y, and Z. It's almost like he's interpreting what the defendant said, and there was at least one objection to that. Why is that admissible?
So I think that goes to the police officer being able to testify as to what he understood from the interview, and then to that goes to the juries whether they credit his testimony regarding his interview with the defendant.
Isn't that similar to, I guess as defense counsel, appellate counsel alluded to, the identification case? The best evidence is the video itself. Why should the officer be able to interpret what the defendant was saying when the video is in evidence, the jury can hear it, and now you're allowing the police officer to sort of give his interpretations of what the defendant actually said?
I think where the video was not very clear, it was more the police officer testifying and using semantics of, I believe he said this. I think that was his takeaway from the interview, but ultimately where the jury did get to see the video and hear the police officer's testimony, I don't think there would be any concern of error there where they could see both and they could see, well, the officer said, I believe he said this, well, what can we hear that he said in the video?
Are you suggesting that the word believe is more the officer's verbal punctuation?
Correct.
As opposed to
Not
him
a-
saying, well, I think that's what it says on the video?
Right, exactly.
So you're saying or I think that's, I remember, or the best of my memory, you're saying it's similar
Right.
to those sorts of phrases?
Exactly, not kind of him interpreting what the defendant was saying during the interview.
Okay.
Are there any other questions the Commonwealth can answer for this court? And we rest on our brief.
I see no further questions. Thank you both very much. Get home safely today.
Thank you.
It's already started.
Next case is Commonwealth versus Farouk Samija, and I apologize for how I pronounced your client's name. Please correct me when you take the podium. This case number is 2024-0306.
Good morning.
Morning.
May it please the court, Kathleen Hill for the defendant, Farouk Simaja.
Samija, thank you.
Yes. This case, we're here on the denial of a motion for a new trial. It's not a new trial, it's a probation.
Violation of probation hearing.
Yeah, it's a violation of probation hearing. From the onset, this case is unusual because I wasn't allowed to file the motion when I first appeared at the court, Rentham District Court. And that was because the clerk and the chief of the probation department believed that this could not be done, that this particular motion could not be heard. In fact, it had never been done in that court. So I'd like to remind the justices of the backdrop of this, of why the conversation, the discussion with the judge occurred. The first hearing was, are you allowed to plead this?
Right.
Can I
But-
ask you a question about that?
Go ahead.
And I was going to ask the Commonwealth, procedurally, what standing does the probation department have to file a motion in opposition to a probationer's motion for new hearing, or
Well-
even argue it?
In this case, arguably, what happens is I go to the district attorney first. And so the district attorney took no position on this. And so then therefore, when you look at the actual hearing of the proceeding, the district court did not, the district attorney did not appear. So then it would have been the probation department that prosecuted this. So, and so then what we try to do is we try to work with the probation department, which is what we did. And then also, too, you will note that because the district attorney took no position, the probation department took a position that they were amenable to a resentencing, but would object to that portion of a final probation hearing with regards to that, and that they had some file. So the judge addressed the issue at the beginning, the starting point is, and she herself wasn't certain if it could be heard. And so that's the backdrop of this. And of course, as you know, that's Commonwealth versus Patton by the time we came back the second time.
So I think your persistence is commendable, but does that have anything to do really with what's before us today?
Yes, it does,
Okay,
Your
tell
Honor.
me
And
how.
that's why I thought, I've been thinking this over. I'm sorry to confuse you, but
No, I'm not
yes,
confused.
because
You explain it to me now.
it just occurred to me, the judge, the primary issue that she denied this was that she felt that Commonwealth versus Quispy
Yeah.
was the governing rule at that time.
Well, she made clear in her comments in the motion to reconsider that she understood that that case had been changed and that it was only relevant to determine whether or not what counsel would or would not have done based
Yes,
on
she
the
did.
rule at a lot at that time, right?
Yes, she did, but I think the progression of law in the Commonwealth of Massachusetts is very clear. Commonwealth versus Sylvain and Commonwealth versus Marino, is that it's retroactive to the actual time, this process. And she was focused on just during that period, that judge at that time, not taking into consideration that it was retroactive, that it would be applied. So I feel that if...
But even if it's retroactive, isn't the inquiry here whether counsel at that time, 20 years ago or so, at that time, representing your client at the violation of probation hearing, would have known, such that his conduct would have fallen below what an ordinary infallible lawyer would do?
I think the motion is supported by the affidavit of the trial attorney. Obviously, what we're saying as trial attorneys appearing before the court at that time, no, he would not have known that Padilla was retroactive and that it applied, and he would have not made an argument. And in fact, that's the purpose of the affidavit. He states to the judge what his common practice was. Obviously, he wouldn't ask for the maximum sentence. No trial attorney would. But what he does recall is that specifically he did not ask for 364 days versus 365, and he wasn't aware that of the consequences that it morphed into an aggravated felony.
What do we do with the fact that the judge was not permitted at that time, technically speaking, for the reasons that it would have been requested to give a 364-day sentence? Not that some of us didn't, because believe it or not, I was actually in the district court in 2002. But having said that, and we all looked and shook our heads, perhaps, or many of us said, well, we'll do the 364, fine. But you were not permitted to legally at that time. And so the lawyers used to couch it kind of.
Sure, and that's why it's excused, the error. The error of the trial attorney at that time, you couldn't possibly have known. It's happened to all of us. The law is modified. We couldn't have made an argument, but maybe we could have made it in a fashion in which there would have been ways which Rule 8D, the mitigating factors allowed, there wasn't even those factors weren't considered.
And there's got to be some demonstration, though, right? At least some demonstration the judge might have done or would have done something different. And when I first looked at it, I said, maybe. But then when I looked at the part where it talked about the extensive prior record that your client came into this with, it made a little less sense to me.
I think the strongest is the equal protection claim under that, is that, as you look at it and you go back, it's under the Strickland standard, it's not that the judge would have done, given the lesser sentence. There's the possibility that would have changed the outcome of this. I ran across a case, 1999, a Superior Court case written by Justice Cowan. And in 1999, she specifically addressed the issue of, for an immigrant at that time, and getting 364 days versus 365. And she said, had the judge known, as in this case she was the judge, you would not have intentionally caused these collateral consequences. It violates equal protection. Why should an individual who, depending on his status, receive a sentence that is 10 times more than what would be given for those particular violations? In this instance, it's not 10 times more, it's for life. This individual was here for 30 years. Why would a judge know and want to give and impose 365 days on an individual? And moreover,
well, it could be that the judge looked and said, look at this person who's been basically a individual crime wave, and maybe the best thing for this community is to have the person deported. I'm not saying that's right or wrong.
That's not the case. That's not the case here, as we know from the record, and as the district court can make that determination as well, too. The record is sufficient to decide this issue. It simply
A couple of
turns on...
things. It's funny that you have a Superior Court case from Justice Cowan, because of course she authored the Crispy case. Many judges at that point in time, as Justice Brennan is pointing out, may have taken immigration consequences into consideration. But after that case came down, all trial judges were instructed that is not in a consideration, correct? Mm-hmm. Okay. So that's the law. We at that point in time. How does that change when you say that Padilla and Marino, et cetera, are retroactive? And Marino, of course, absolutely overturns that case. Why isn't that snapshot, and this is what I'm still having some struggling with, why isn't that snapshot in time accurate? And
Because, Your Honor, it's fundamental, it's basic, it's a principle. We applied a law at the time, and it wasn't right. We can think of other laws that were not right. And so the purpose of equal protection and retroactivity...
I understand that. And this is a difficult case, because, of course, things did change considerably, potentially in favor of your client, right? So I understand this is a difficult case, and I appreciate the passion. But the issue is not just what law we're applying, whether it's correct or not, but what counsel would have done based on that snapshot in time.
I think that's could be drawn and should be drawn from his affidavit. He would have, had he known, and he didn't know, that it morphed into an aggravated felony, a simple misdemeanor, you wouldn't have, that would be in violation of your CPCS, your ethical duties and representation of your client. You must zealously advocate for a sentence that is fair and reasonable.
So let's assume that this is like a normal ineffective assistance counsel claim. What should defense counsel have argued?
Well, he's excused. That is why it's retroactive. It's a constitutional right. We recognize these constitutional rights that are embedded in our Constitution, and when they're interpreted or the laws are amended to change, we apply them, we correct them. That's what I'm asking this court to do.
I understand all that, but under the ineffective assistance prong, you have to show that better work would have accomplished something different. So what would his better work have been?
His better work would have been, had he known, he would have advocated for that.
But he couldn't legally. He couldn't go argue. It's almost like jury nullification. He couldn't go up there and say to the judge, 364 days so he won't get deported. That would have been an improper argument. So what would he have argued?
I think you're looking back, you're not taking, excuse me on that, the principle of retroactivity means there's no blameworthiness.
That's not an answer to the question. We haven't heard an answer to Justice Danto's question. What should have he said?
Well, I did state my brief what he should have said. Obviously, he would have advocated for less, maybe even 6 months, because he hadn't received a sentence on this subsequent offense more than 6 months. I mean, ideally,
the other wrinkle, and what you have addressed, but you might want to have an opportunity to address it again now, is the judge was aware of the immigration consequences here, because your client had been in removal proceedings and had just returned from Louisiana. So it wasn't as if the judge was unaware of the consequences, maybe, we don't know, but not unaware of your client's predicament.
Right, but that wasn't the issue, and that's not why we're before the court, and that's not why we filed it. The issue was not whether or not the judge was aware. The issue was they were not aware that imposing the maximum sentence of 1 year morphed a misdemeanor into an aggravated felony under federal law. Yes, the defendant says, yes, I explained to the judge while I was while my attorney was representing me, I wanted to speak. I wanted to explain what I have done, as if his record was looked at, and the judge knows this, he has always done. He has always taken responsibility. He has always been forthright, and this is what he did. He himself didn't know it was going to morph into an aggravated felony.
Did it make a difference at all whether this was an admission to violation, or as it's referred to, a stipulation, versus a hearing, where the judge took evidence and found your client in violation? Does that make a difference in terms of?
I'm sorry, are you saying
Sure, the question as to whether, whether the defendant, whether the probationer at that time, your client, admitted to the violation versus was found in violation after a full hearing? Does that make any difference to our analysis?
Well, it would, but not to this case, because he did admit to it.
How do we know
as
that?
he had done other ones, because
how do we know that? My understanding when I read and I look at the record is the record's lost. And
Because
the Commonwealth points out that
you
there's
know
sort
that,
of
Your
different
Honor-
docket language, thanks, there's different docket language on this as opposed to another, from which someone, I suppose, could infer or speculate that.
No, it's on the docket, Your Honor. If you look
Yeah.
at the handwritten docket, you will see violation of probation found.
Right.
When you stipulate to it, there's no finding. It's by stipulation. They always put down the stipulation on the docket sheet.
Using the term always in terms of a district court docket, I think you're on very dangerous territory, especially the handwritten ones. And some they write them on the outside of the file, some they used to
Yeah.
write them on the inside. I mean, you know.
Yeah. So we're relying on that with, given the basis of the docket, and so that was.
So it's your inference from the docket, that found means that
yeah, I think-
there was a hearing, but we don't know.
Yeah. And then I think there was another hearing before, if you look, a couple months before, specifically with regard to restitution, and the judge allowed probation to set the amount of the restitution. If there are any other questions, I see my time.
Thank you
is
very
up.
much.
Thank you.
Good morning, Your Honors. May it please the Court, Kristen Kelly for the Commonwealth. The motion judge here did not abuse her discretion when she denied the probationer's motion for a new violation hearing. As was pointed out, the assessment of counsel's conduct has to be taken into account as of the time the conduct was made, in light of the prevailing professional norms and the facts and circumstances that were known to counsel at the time.
May I ask a question that really has little to do with perhaps the legal issues here? So the Commonwealth did not take any position on this. Essentially, it was like conceded it at the time, right? And other than the fact that there's an appeal and I suppose you have to show up, why do you care now?
I think at the time that we took no position was that this is probation's matter and that they were going to handle it. When we were notified of the appeal, we did reach out to probation, and they indicated that the individual who had written opposition was no longer with probation, and that it would kind of be a complicated process.
To Justice D'Angelo's question way back, what standing does OCP, I assume that's, I don't know if they weren't called that then, but what standing does probation have in this sort of a case? It seems to me this is a Commonwealth.
I think they have an interest
district attorney issue.
Yes, I think they do have an interest in maintaining and preserving their finding of violation. We did not participate in the violation hearing, but I would argue, do have an interest in preserving that and making sure that that violation stands.
So on any case where there's a violation of probation, you think the office of the probation can file an appearance, have a lawyer come down and argue it?
I don't know that absolutely, but maybe they could have the option to. But yeah, at this point, our interest here obviously is in align with the judge's findings and to make sure that her findings stand, because we do find that, again, the QUISP was the case law that was at the time, and assessing his reasonableness and the conduct, whether an ordinary fallible attorney would have done something different at the time, we can't say that. It's not there where he followed the law at the time. The retroactivity analysis, so Marino did overturn QUISP in the footnote. But I would clarify that the Sylvain application of Marino, the retroactivity, focused on Marino's holding where it applied Padilla obligations on counsel in situations where they decide to go to trial. It did not apply the holding in Marino about counsel's affirmative duty to argue for a lesser sentence in order to avoid immigration consequences. And I would submit that that's because that is a new rule. It is contrary to...
Are you saying that portion of Marino is not applied retroactively? Is that your point?
Yes, because that is contrary to case precedent at the time. So when that was decided, it was overturning a prior case, and the retroactivity analysis where if it's a new rule, it's not applied retroactively. So the other holdings, yes, it's the same coin as Padilla, where it's the duty to inform your client the consequences of pleading, applying that to decision to go to trial and the conviction of it.
Is there a principle of fundamental fairness that nobody in the court at that time, at least according to the record, seems to have known that giving him this sentence was going to turn it into a federal felony and therefore be deported? Doesn't that sort of cut against fundamental fairness that nobody knew that this was going to be the result? And that should err to the probationer?
I guess potentially, yes, but I think at the end of it, the judge could not have considered it anyway. So whether it's under, an equal protection argument, the reason it has that disparate impact is because of the immigration consequences. And given the case law at the time, the judge could not have considered it. So I think for that reason that, counsel here was effective. So if there are no other questions, thank you. I rest on my brief. Thank you.
Thank you.
Very much. The next case is Commonwealth versus Nicholas, I'm going to pronounce it Goussier. Please correct me when you come to the podium. Case number 2023-1506.
Good morning.
Good morning.
May it please the court, Genevieve Henrique for...
Could you please step to the podium? Thank you. We need to hear you better with the microphone, and it needs to be recorded as well. That's okay.
My voice does travel, but yes, I just was a little excited there.
One second, make sure the light goes back on for you. Hold on, I don't see it. There we go. Thank you. Go ahead.
Let's try again. Good morning.
Good morning.
Genevieve Henrique for Nicholas Goussier. May it please the court, this is a case where there were blatant violations of the first complaint doctrine, which created a risk of substantial risk of the miscarriage of justice. This is true particularly in light of the fact that there was absolutely no jury instruction with which the jurors could have understood how to properly consider the evidence that was in front of them, which was not first complaint evidence as pondered by King in any way. There was no first complaint witness. There was a witness that could have been available, that was clear from the record, the father, but he was never called by either party. It was never presented as a motion to eliminate to bring him. It was never discussed. There was no careful analysis of the judge of this body, this doctrine that he would have, and he could use his discretion to analyze and properly introduce this evidence. Wasn't that sort of situation that other cases have looked at where a judge perhaps deviated from what King initially had, well, King has certainly deviated from what it initially had in mind, but used that body of doctrine. No, this was essentially, unfortunately, a circus in which Mr. Goussier ended up suffering.
So can I ask you about that part of it? Because look, I don't disagree. There was no limiting instruction at the time as if it was first complaint as required. There was no instruction to the jury in the final instructions. Having said that, and I'm not sure, I'm trying to wrestle with, is it the order in which it happens? Your client's defense was recantation and essentially inconsistent statement, right? for which there was no limiting instruction on prior inconsistent or consistent statements, but we'll leave that to the side. Assume for the moment his defense is recantation. Is the Commonwealth not entitled to say, okay, recanted, but inconsistent statement, although again it came in substantively, so it does confuse it. But gave a consistent statement to father, mother, anonymous person, whomever that may have been, the CAC or DCF, I mean, you name it.
So first of all, I think you used the word assume, and that's as far as what the defense strategy was, and let's just.
Well, they opened with it.
They opened with, they did with the inconsistent statements, certainly, but more the focus of the defense, I would suggest, was more on the inconsistencies of her memory and the timeline and when they lived there. And the recantation, though I'm not going to try to argue that it wasn't used at times throughout the case, I would suggest that if it really was the focus of the defense, there were several areas where trial counsel could have pursued that, particularly when he put on the defendant's case and called mother. He never followed through with the recantation at that point. He recalled Detective Hart. He never followed through with recantation. And at that point, as Commonwealth would suggest, the door certainly was open as to that being substantive and on the table. It wasn't pursued.
So suppose instead of putting the detective on first, which again, the case law is pretty clear that is fraught with danger, which seems to have been realized here, but assume the victim testified first, okay? And is and testifies only to what happened, and then is cross-examined about the recantation, if you will, and the inconsistent statement. At that point, assuming that, I'm trying to get my head around it.
Yeah.
Assuming that,
Me too.
would the Commonwealth have been entitled to put in, at least within the judge's discretion, some evidence of, well, I told my father, and I told my father exactly what I'm telling you. Well, I told my friend, and I told my friend just the same thing. Well, right?
I think that at that point, an issue could have been raised, brought to sidebar, and argued based on whether or not there was a foundation being laid, whether there was, it is different from cases where those inconsistent statements were opening up something that was clearly a laid out strategy, and that was never brought, and it was never analyzed by the judge, so a judge never the trial judge never entertained whether or not that would have been admissible. It just was back to the circus that it was of complete violation of the doctrine.
Well, if it didn't come in on impeachment, or if the Commonwealth in rebuttal to the impeachment, if it's not coming in for fresh complaint, which it clearly couldn't have, the only way it would have been admissible would have been as a prior consistent statement, correct?
Correct.
And defense counsel's cross-examination suggested that the motive to fabricate was very early on, almost at the beginning of these allegations. Isn't that right?
The motive to fabricate versus the suggestion that it was, I disagree that the defense strategy was that there was a motive to fabricate. Again, it was not that an assault occurred, which goes back to, again, the original purpose of first complaint. There really was no argument that an assault occurred. It was more in this, and the recantation doesn't go against this as a defense strategy. It was whether or not there was another person, whether it was identification, which, as we know, first complaint is not supposed to go towards identification.
What about as an appropriate response to the delayed disclosure issue? I mean, it certainly doesn't help as it relates to the report to CAC or DCF, but in terms of telling the father, telling the mother, at the time, as opposed to it being delayed 7 years.
Well, of course, it would have gone to delayed disclosure and been potentially admissible appropriately if it had been admitted appropriately, and that would be by calling father, but it wasn't. Yes, of course, first complaint testimony can go towards curing issues with delayed disclosure. I would suggest anyways, maybe I shouldn't be that, but I would suggest that certainly.
I'm saying not as first complaint, so say there's the testimony and the cross-examinations, well, you didn't tell anybody for 7 years, and then the redirect is, well, in fact, whom did you tell? Well, I told my dad the next day, I told my mom the following week, and then I kind of got all nervous because the family was ganging up on me.
If Commonwealth had elicited that, are you saying? Or if
No, I would have been on cross, presumably, the delayed disclosure. I suppose they could have anticipatorily done so, but, yeah, okay, I think yeah. just trying to wrestle with how to get my head around what exactly this was, because it really was, everything came in substantively. Even the recantation, if you want to call it that, it didn't happen, came in substantively, which it shouldn't have, right?
Correct. I would agree, and I'm glad I'm not the only one wrestling with this, as I have done for several weeks. I'd like to speak briefly on the juror issue, unless there's any other questions on that issue, and certainly answer any questions. But then I would suggest also that, especially in light of the issues that we were just discussing, and I would suggest that this, even though there was some objection as to the first complaint coming in at some of the inadmissible first complaint testimony coming in, I do suggest, as I do in my brief, that it is a miscarriage of justice review. I would suggest the totality of errors, including the judge's failure to properly inquire as to the juror who 4 minutes later apparently made a decision, certainly goes towards the harm that my client suffered as a result of, again, several errors that occurred during this trial. And
so in that, I don't want you to dominate the questioning, but that makes common sense to me, right? That you should have kept the juror out of the room. But is there any case that says, when the cases seem to say the judge has discretion as to whether to suspend deliberations?
I haven't found anything
Probably didn't expect it to be 4 minutes later.
I think the term common sense is so important to this argument, because that's really what it is. It's, as human experience, what can we say about what was wrong, what feels wrong about what happened as you read that transcript. As to a case on point, no, most of the cases I cite in both my principal brief and reply brief are to juror impanelment in general. Certainly, I think the argument that it would be some sort of discrimination against the juror for being, that Commonwealth makes in their brief, that it is completely unfounded, because really it's quite the opposite. It would have been a judge inquiring and then potentially dismissing based on just individual's own experience, stating that he's incapable.
So if you're writing the rule, you're us writing the rule, what is the rule? When the juror raises a concern, you must suspend deliberations case by case, and in this case, should have, even though it's discretionary, abuse of discretion? Where are we on that?
I think we can look at this 2 phases, which would keep it open to potentially being a discretionary rule. I think the judge could have properly. The judge didn't know that it was going to be 4 minutes before they came back. In fairness to him, that's the case. So let's say he used his discretion and didn't instruct the juror. When they did come back 4 minutes later, he did have the opportunity to poll the jury at that point, and he did not, even against the.
Yeah, did that make him? There's only 6 of them, and they say, "So say you." It's a
still,
four-person. So say you all, and all of them say yes, and you hear them say yes.
It would have been something, or there could have been something on the record. It could have been an inquiry. I mean, it could have been, again, just recognizing that this judge did not, and being human and all of us fallible, he didn't know that this was going to turn around 4 minutes later. But do I think that there could be a better vetted rule?
Almost 4 o'clock. I'm sorry, I'm just saying, when you say nobody knew, I mean, it was a few minutes before 4 o'clock when the day ends.
True, but 4 minutes, I mean, 4 o'clock, 4:30, it was truly 4 minutes that they came back, or even less than.
I recognize that.
But yeah, maybe they should have known. And in this case, certainly, I would suggest that the judge should have used his discretion to continue the recess that was requested by both parties, hear from both parties. They were going back, it seems from the record that they were gathering case law, and to then take what they had and properly vet whether or not this juror should have remained in the juror.
One other issue I'd like to ask you about before your time, and that is, and I know you don't agree with it, but assume for the moment that we determine that the prior bad act evidence, at least as it relates to the splits, was properly admitted. Okay, putting aside that the tens or hundreds of other acts of indecent assault and battery that were not charged in the complaint were never vetted, putting that aside for a moment. Does the absence of a limiting instruction, either contemporaneous with the admission of the evidence or in the final instructions, by itself create reversible error?
I think it does. I think it's clearly it clearly is a situation that called for some jury instruction at some point, and the fact that it was a complete...
You have a case that says that, because I don't think I saw it in your brief, a case that says that if prior bad act evidence is properly admitted, but the jury is not instructed on the limitations, that is
reversible.
Reversible.
I don't have a case that is on point to that, but I would suggest that and again, looking at this as a totality and all the errors, then certainly it should be reversible. But just for that alone, I think it should be given these circumstances, but I don't have a case on point. Barring further questions, I'll rest on my brief.
I see none. Thank you very much.
Thank you.
Good morning, Your Honors. May it please the Court, Stephen Nato on behalf of the Commonwealth. Before I get into the first complaint issue, I think I must begin as Attorney Mary Lee, who wrote the brief, began by acknowledging the problems with this record. Grave concerns, not how it should have been done, and aside from an action from trial counsel or the judge, it was incumbent on the prosecutor to be sure that the evidence we present in a criminal trial is done properly. And that was not done here. I can inform the Court that was addressed with the prosecutor herself and has been addressed in training and frequency of retrainings generally across the board.
Thank you.
Be that as it may, I think relying chiefly on McCoy, although a couple other cases, the numerous evidence of multiple disclosures and the absence of the limiting instruction does not give rise to a substantial risk of miscarriage of justice given the defense strategy here, which was both to highlight the recantation and also to challenge the adequacy of the police investigation. And so to that end, the sort of circumstances surrounding the recantation and then what prompted her to come forward after so many years, I think is admissible. And then how the law enforcement heard about the disclosure and how they responded to it, I think then becomes admissible to explain their own actions in the case.
What about the fact that, putting aside the opening, which is an evidence, the Commonwealth was the first one to put it out there by putting the detective on first, and then getting in that there was a prior disclosure to a mandated reporter and naming the alleged offender. I mean, that was the first foray evidentiarily, if you will. Right? Yes,
and again, I have no defense for how it was done here, but just, the case was clear that this was an allegation against the defendant, likely or almost certainly would have come in had the order been proper.
Do you think there are any circumstances where this detective should have testified regardless? I mean, it used to be, again, in the old days, you put him on just to show you did an investigation, but I think the cases are pretty clear now. You can't just prop up the police officer with nothing to say.
I agree, and certainly from our perspective, I know that the defense wanted to call her as a witness and did, in his case, for other things. So on our cross, could have rehabilitated through that. Again, not how it should have gone here, but I think in substance, properly drawn out, the substance would have come in basically the same. And given the defendant, and I think that's McCoy, and I think I'd also refer to Hanino, specifically at pin site 496 in that case, where they talk about, in that case, the victim's uncle and brother both expressed, there was evidence of their reaction and also the pressure they put on the child in that case. And so I think the evidence here, again, if had it been followed the proper procedure, would have come in under that same principle as well.
A lot of this evidence, I hear what you're saying, that it may have come in properly if it had been in the right order. But there's another leap to that, which is if it came in properly in the right order, there would have been a limiting instruction if it had all been followed properly. Mm-hmm. How do we, and this goes back to Justice Brennan early on, struggle with the fact that all of this just comes in for everything. How is that not a miscarriage of justice when the case law is clear that those instructions are there for a reason?
I agree, and this is a tough record, but that's, I think, McCoy. Again, there was no limiting instruction there, and there was testimony, again, not just the victim, but the detective, the victim's mother, and I think the same nurse also testified. So a lot of the problems in McCoy are present here, and this court nonetheless found no substantial risk based on the defense. And so I think, again, it is the nature of the defense that, if we were looking at this thing for prejudicial error, perhaps, but I do think McCoy at least stands for the proposition on this record.
Do you agree with the proposition that all of the testimony regarding the indecent touching 3 times a week over some undetermined amount of time, but many times, was all prior bad act evidence, at least as this complaint was charged? It wasn't on diverse dates, it was on, maybe even on or about a date. A singular act on or about a date is how it's charged, right?
I mean, that's the complaint. It's, it's not actually an element. The defendant didn't challenge variance. The fact that, and this ties into the second issue of the prior bad acts, but the jury were clearly instructed you were here about a touching. There was only one kind of touching really discussed here in one particular context, the bedtime routine. So I don't think any variance on that ground was prejudicial here, but I think that was all kind of evidence of the touching that was alleged.
Well, your problems aren't over. We still have to talk about the juror.
Yes. And if there are no questions on that, meaning on the first, it is what it is. But turning to the juror issue, there I think the judge acted well within his discretion. Obviously, the juror was having some concerns with his faith and his role in the system, but those were sort of kind of generalized, almost like ruminations on his own, devotion and what his role in it. There's nothing that seemed like he couldn't do it. He just had concerns, and I'm not aware of any case that says...
It seemed like he was pretty clear by expressing the fact that he was concerned about whatever decision he made would have an effect on him personally in another cycle of life.
Right, and I think that is sort of consistent with, your own conscience, how you deal with that in the jury deliberation room. I think while couched in sort of a faith-based context, it's not sort of unique in that regard. I imagine there's a lot of discussion like that goes on in the deliberation room. Here was clearly more acute for this particular juror, but then he was sent back, and they came back with no sort of prodding to get over it from the judge. Really, just kind of asked, "Do you think you can still deliberate?" That he was sent back while the parties sort of tried to figure something out, and he came back with a verdict. And when the jury was asked if it was unanimous, he said yes, or he indicated his assent.
As far as polling, just trying to think this through, do you think the judge had the discretion, given the length and the substance and the depth of concern that this juror expressed, had the discretion after the verdict to voir dire that juror individually and to affirm? I've never seen it, but I mean, you poll them in the courtroom and everybody, one at a time, yes, 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 or guilty, 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 whatever it may be. Do you think there's any room for the judge, if there was some concern, to say, let's bring juror 17 back up here and say, boy, it's 4 minutes. Did you really satisfy all of those rather apparently deeply concerning issues that...
I think, I'm familiar with, if it comes to light that a juror is exposed to extraneous information, you can call them back after the verdict, so perhaps there's a discretionary thing, but I don't think anything required the judge to do that here. And again,
What about basic fairness and maybe getting the right result, if you will, and making sure it wasn't a result of tick-tock, it's 4 o'clock, pressure, come on, let's go?
I don't know that there's any indication that that's what it was. Again, the concerns were
to my point, how do you?
Personal, spiritual, and generally we have no idea what goes on in the minds of jurors when they're deliberating, and we're not supposed to. But again, here he's not saying he can't do it. He just has these, religious-based concerns that he's not saying I refuse to do it. I object. I'm just thinking about this, and then perhaps, and speaking them aloud, gives him some clarity, because then, again, obviously 4 minutes later they come back.
I don't think we can ignore the fact that this came to the judge's attention, as well as counsel, because the foreperson wrote a note indicating that there was an issue with the jury. So there was more than just a juror ruminating and trying to wrestle with conscience, et cetera.
And I think that's somewhat ambiguous. We don't know if, again, we don't know what the discussion was. If the juror at issue said, I'm having this problem, and the foreperson asked, would you like me to flag this for the judge as the foreperson, or if, the foreperson was alarmed. We just don't know. I don't think there's any indication there's nothing particularly explosive in what the juror says. I don't think that,
Well, is it reasonable to infer that the jury deliberations were being affected by this juror's
I don't know that there's
ruminating, as you put it before?
There's no, I think, indication of that necessarily. The note referenced only this one juror having the issue. There's no indication that and it's a very personal issue to that juror. There's no indication that it spread. And there's no indication that the juror felt a religious conviction that he had to convict, but for some reason couldn't, or either way. I think he seemed pretty...
So as an experienced appellate attorney and one who probably prefers a clean record, what would have been the better, or if you think there would have been better practice for the judge in this situation when confronted with this particular juror and the attorney saying, well, can you give us a couple minutes to figure out what we want to do here?
Well, I think the better practice would first have hopefully gotten a clearer answer from the juror. Do you believe you can continue? And then, I know you're getting to the end of the day there, perhaps suspending for the day, letting the parties come back in the morning. But again, I don't know that any of that was required here, and I would suggest that the judge...
Required or not, that the judge said, quote unquote, the issue is now moot. As far as the judge was concerned, once he was notified, he or she notified that the verdict came in, that was the end. That was the end.
Right.
Right. And so was that permissible, a discretionary call, or was it more of an error of law? Because at the same time, permission had been given to counsel, both of them, to address the issue. I think the judge said, go out in the hallway and see what you think. And so two things were happening at the exact same time.
Yes, and so I think I'm not aware of any authority that would suggest it is a legal error or outside discretion specifically, nor do I have any case directly on point that says this was A-okay, but I do think the judge's reaction shows his own personal, not this wasn't dynamite or something. This was what it is. It's over now. And if he had, strong convictions that this was a real concern in the moment after talking to the juror, something else could have been done. But the record doesn't show that.
When is it ever an abuse of discretion not to poll a juror? Because I hear you when you say maybe not an abuse of discretion, and I'm struggling in my mind right now. Not necessarily if this isn't the case, I don't know what one is, I'm not going that far. But when is it an abuse of discretion?
I think perhaps if there's some indication of, a hung jury or disagreements among jurors, again, you can't inquire too substantively into the substance of deliberations.
Well, the reason why I ask that is, can we infer from the judge saying they're nodding their heads affirming or whatever he says, that is sort of an informal polling in his mind. I guess the corollary to that, or the converse to that, would be if a juror's going like this,
Right.
maybe that would force a polling. But
Yes.
can we take anything from that he says they're affirming by nodding their head?
I think so, yes, yes. I mean, the judge is, present for it. He had the prior conversation with this juror who had the concern. He's able to view his demeanor both during that interaction throughout the trial and then when they announce the verdict, and he confirms that it's unanimous. And there he sees no problem, and I think he is within his discretion in so deciding. I see I'm running out of time here. Happy to answer any other questions if there are any.
Thank you very much. Thank you very much, and thank you for your candor as well. We appreciate it, as always. And also to the two of you, safe trip home. Doesn't look like it's too bad out there, but be careful. The next case is number 2024-0389, Yuri Margulis versus Danielle Rivlin. I guess that would be Daniel Rivlin, excuse me. Good morning.
Good morning, Your Honors. May it please the Court, Jeremy Weltman for the plaintiff appellant in this matter, Mr. Margulis. This appeal requests that this Court reverse a motion to dismiss that was allowed in the Superior Court based primarily on litigation privilege. The facts in the timeline of various real estate attachments are important here. Allow me to go through that unless you have something to interject with, of course. On May 16th, 2019, Attorney Rivlin, who's the defendant appellee in this matter, through a Massachusetts law firm, Butters Brazilian, recorded 2 mortgages on property at 12 Morton Road, in Newton, Massachusetts.
Right. And your client already had 2 other attachments at that point, right?
Your Honor.
Okay.
At the time that those mortgages were recorded, there was a $350,000 attachment that went on record in November of 2016. And there was a July 2020 mortgage, Uniform Fraudulent Transfer Act judgment that was rendered in an MSJ, which was $476,000. Between those two, the May 2019 Butters Brazilian / Rivlin mortgage goes on record. Thereafter, there is some motion practice undertaken by my client, to first try to dissolve those attachments, and then if not, to try to get some priority ahead of those attachments. Ultimately, the motion to dissolve the attachments was denied, but as part of the order and the judgment on that decision, the judge says, we're not going to allow you to dissolve the attachments, but that second attachment, the one for $476,000 that came in on the UFTA MSJ, will be applied nunc-pro-tunc, meaning it goes ahead of...
Hey, counsel, I guess I do want to jump forward.
Sure.
We're familiar with the facts. The complaint is primarily based on things said during the litigation. Why isn't that covered on all those complaint counts where they're talking about what the attorney or his client said during the litigation? Why isn't that strictly covered by the litigation privilege?
It's a great question, Your Honor. I'm going to point the court to the Basicus, I may be saying it incorrectly, case, and I want to compare that to the Kirker case, which is also referenced in the Basicus case. Basicus is very clear that it says, look, it can be any act or communication, right, that's covered in the litigation privilege. But I suggest to the court that if you read carefully the opinion of Basicus, it doesn't give you a blank litigation privilege for anything that happens in litigation. It says that the communication or the action has to be related to the specific litigation at hand.
So on that, wasn't one of the issues that was contested and remained open attorney's fees?
Well, the issue of attorney's fees with respect to Mr. Rivlin was always, or with respect to any counsel, was sort of left open, right? Because the automatic order, so you
But
can't
it was
pay.
listed, as I understand the argument on the other side, is that that was a contested issue, and so that conduct relating to that issue would be conduct related to the proceeding and therefore covered by the litigation privilege. I may not be getting it exactly right, but that's my sense of it. Why not?
Well, first of all, there's two reasons. Number one is, while the issue of attorney's fees was quote-unquote left open as part of the ongoing divorce proceeding, the automatic orders are very clear. And the automatic order said you can't encumber any property, joint property, even for attorney's fees until there's
That
agreement.
sounds like it's a great argument, which I think was made in the New York court. What does that have to do with how it's not part of the litigation privilege?
The reason it's not part of the litigation privilege, respectfully, Your Honors, here, is that there's two pieces going on here.
There's what, excuse me?
There's two mortgages that happen to go on record
Could you
here.
please talk a little bit closer to
Absolutely.
the? Yeah,
There's
thank
two
you.
mortgages at issue here. They're both recorded at the same time, but one is for $100,000 for Mr. Rivlin's case. I suggest to you that that is part of that litigation. They go to Mr. Rivlin's attorney's fees in the divorce proceeding. The issue I take here, and the reason I'm trying to raise a distinction here in Basichis in reference to Kirker, is that it also included $350,000 to pay Massachusetts lawyer for Massachusetts litigation that had nothing to do with the divorce proceeding. All right? It was, and the Brothers Brazilian affidavit, which referenced in the papers, says, Mr. Butters, I recorded these two mortgages, one for $100,000 for Mr. Rivlin's fees and one for $350,000 for my fees, at the direction of Mr. Rivlin in New York. He told me it was fine to do it. He wrote up the papers. I just recorded it. I suggest to you that if this was simply a case about the $100,000 mortgage that paid for Mr. Rivlin's fees in New York, it would be encompassed under Basichis. But I suggest otherwise, that because it also included $350,000 of attorney's fees related to a completely different litigation that had nothing to do with the divorce, that it comes outside of the penumbra of that overarching protection of litigation privilege that Basichis lays out for us. There's a difference here, because unlike in Basichis, which, yes, has to do with the fact that there's an allegation that the attorney moved forward on a trial or divorce trial that didn't need to be done because he's trying to exclude creditors of the husband, that all had to do with that case, that divorce proceeding. This is different, and it's different simply because it includes money for litigation in Massachusetts. Massachusetts litigation that my client undertakes against Mr. Bitton has nothing to do with Anna Bitton, has nothing to do with the New York divorce, has to do with business litigation, claims of malfeasance with respect to development of property, arbitration award that he gets in that respect, a Uniform Fraudulent Transfer Act award he gets in that respect, a judgment he gets recently in their assessment of damages hearing, over $2 million in that respect. This is a separate situation. My client isn't going after Mr. Rivlin for what he did in New York. My client is going after Mr. Rivlin for the way that he orchestrated a conspiracy, I suggest in the complaint, or fraud on Mr. Margulies with respect to his claims in Massachusetts, independent of the divorce. To me, that's the difference between the Basichis trials, or excuse me, the Basichis opinion, and how it ties in if you look at the details of the Basichis opinion on page 17 when they start talking about Kirker. Kirker versus Hill, 44 Mass App, right? They say, the plaintiffs in Basichis rely on Kirker, saying it's different. The court in Basichis says, well, it's not different because here, all of the counseling had to do with the litigation of the divorce proceeding. In Kirker, yeah, he did some litigation counseling, but there's also what they called business matters counseling generally, rather than preparation or conduct of litigation. The attorneys in Kirker provided legal advice and services in connection with the purchase and sale of corporate assets. Their assistance was not confined to litigation. The same goes here. The assistance with respect to the $350,000 secured here in Massachusetts, from Massachusetts fees on a Massachusetts property, had nothing to do with the divorce in New York. And frankly, I think that it could be qualified as not being effort that was put forward by Rivlin with respect to litigation, but more as assisting clients in business matters generally. And if that's the case, if that's a wrinkle here that takes it out of the Basichis encompassing litigation privilege that we all know now to be very broad, then I suggest to you that Mr. Rivlin shouldn't be allowed to escape justice here, or at least have my client have a day in court, have it dismissed on a motion to dismiss on the front end, simply because of application of Basichus, saying that generally speaking, and I agree with this, generally speaking, litigation privilege is very broad with respect to any acts or communications related to that litigation. That's the difference, Your Honors. Any other questions I can answer for you?
No? I see no questions.
Thank you.
Thank you very much.
Good morning, members of the panel. May it please the court. Melissa Bailey on behalf of the defendant, Daniel Rivlin. This case presents an archetypal example of application of the litigation privilege. The trial court properly dismissed all of plaintiff's claims because they all arose out of statements and conduct made by Attorney Rivlin during his representation of the plaintiff's ex-son-in-law in his divorce proceedings in New York. As the Supreme Judicial Court made clear, and now I don't know if I'm pronouncing this correctly, I was going to say the Basichus case, but I suppose when on the transcript it'll read the same. The litigation privilege provides absolute immunity to all attorney statements and conduct that has some relation to the litigation proceedings. It's so broad.
The purpose, right, if I read Basichus correctly, is because you don't want attorneys to feel like they have to divide their interest between advocating for their clients and protecting themselves from some sort of, and I'm quoting, retributive or retributive suit, right? So that's the underlying purpose of it.
Exactly, and that's why it is so broad.
How does filing something to cover your own fees, how does that in any way support that purpose?
Well, I'd like to answer that in two parts. So first of all, we think that the litigation privilege absolutely covers the collection of attorney's fees. But first, that's not what this case is actually about. If you take a look at plaintiff's, well, first of all, in plaintiff's brief, he states that recording the mortgages, and I'm going to quote directly from his brief here, in and of themselves and in a vacuum is not an improper act. So here, this is where I want to clarify what the case is actually about, and it's about the statements that created what plaintiff calls a conspiracy or a tortious plan, and all of those statements and conduct occurred during the divorce proceedings. So if we take a look closer at plaintiff's actual complaint, the allegations in the complaint, which I submit are different from what we've heard on appeal in the argument today. He asserts 6 claims: civil conspiracy, negligent misrepresentation, reckless misrepresentation, fraud by omission, intentional infliction of emotional distress, and negligent infliction of emotional distress. Each of these claims requires more than a simple act of filing a mortgage. The only other conduct that's alleged in the complaint is conduct related to Mr. Rivlin's representation of Mr. Bitton in the New York divorce case. And I can go through the examples here. It's all laid out in paragraph 23 of the plaintiff's complaint. He has subparts A through G. In A and C, he alleges that Mr. Rivlin misrepresented the equity in and obligations on Mr. Bitton's property to the court during the divorce case. In paragraph 23B, he alleges that Mr. Rivlin permitted Bitton to pay his Massachusetts attorney's fees. It's not clear how this relates to the priority of the mortgage in any case, but this was still conduct by Mr. Rivlin during the divorce case. In paragraph 23D, plaintiff points to statements Mr. Rivlin made in a motion in the divorce case. In paragraph 23E, plaintiff alleges that Mr. Rivlin omitted information from a May 28 stipulation of facts in the divorce case. In paragraph 23F, plaintiff refers to a statement of accounting for work done in the divorce matter that was submitted in response to, submitted by a different attorney, Attorney Butters, in response to the motion to dissolve the Butters Brazilian mortgages. In paragraph 23G, plaintiff does not identify any statements or conduct by Mr. Rivlin. He just says that the timing of the mortgage was suspect. So all of these allegations pertain to Mr. Rivlin's conduct and actual statements during the divorce proceedings. If you eliminate those from the complaint, the only remaining claim is that he filed a mortgage. And I don't think plaintiff even claims, and as I've stated, he concedes that that alone is not sufficient to satisfy his burden.
Isn't part of the allegation that your client orchestrated the filing of not just the first mortgage for $100,000, but also a second mortgage?
Yeah, that's the first time that we're hearing that argument. That was not part of the briefs on appeal, that the real subject here is the orchestration of the second mortgage. There's no facts indicating that Mr. Rivlin had anything to do with that. That mortgage was not filed by him. There are no communications indicating that he had anything to do with that, no allegations in the complaint that he somehow caused that to happen. That was filed by a different law firm for attorney's fees in a different case in Massachusetts.
They weren't filed at the exact same time?
They were filed at the same time, but for two different things, and Mr. Rivlin had nothing to do with the cases in Massachusetts.
I thought I understood from the complaint that that was part of the alleged civil conspiracy, that the two mortgages were filed at the same time, and that actually ended up protecting your client, or is that?
I think that is conclusorily stated. It's
Okay.
not clear to me how that would affect, why Mr. Rivlin would have been involved in that, or how that would affect him. I do believe that that statement is made, but
Okay.
without any other support.
All right. Would that be a statement in your view that we could accept as true, given the posture of the case being?
I'm not sure what the statement is. So the statement is that Mr. Rivlin,
Allegation, I guess it would be.
yeah, the allegation is that Mr. Rivlin was involved in in Butters Brazilian's filing of the mortgage for Butters Brazilian's attorney's fees. Yes, you have to accept that as true, I suppose. But again, without all of Mr. Rivlin's other statements in the divorce proceeding, don't see how that alone would would give rise to a conspiracy or support any of the other claims in the complaint. Do your honors have any other questions?
I'll just check with the panel. Don't see any here, don't see any there. Thank you both very much for your arguments.
Thank you very much.
All right, we're going to keep going, not take a break this morning because I see the weather is continuing to snow. We want to make sure we can get home safely. So I'll call the next case, which is 2023-1479, the Cook Family Charitable Fund versus Frozen 4 LLC, and another. Morning.
Good morning, Your Honors. Good morning, Your Honors, and may it please the Court, Ed Daly and Elizabeth Patonova, on behalf of the Cook Family Charitable Fund, and Mr. Cook has joined us today and braved the weather. We raised a number of issues in our appeal, but I want to jump right to the critical errors in the judge's analysis below. The first is the judge engaged in fact-finding at the motion to dismiss stage, and that critical fact that dictates his analysis was that the only thing that the charity was required to do to receive the donation was submit the letter of support. That's not what the complaint says. The second error, and this compounds that first error, is that the judge only looked at single statements in the complaint and not the complaint as a whole when assessing what the claim here was. So instead of looking at the complaint for what it was, which is allegations of 2 years of promises made, promises broken, and the charity being strung along with the promised donation just around the corner, the judge looked at these different misrepresentations under a microscope, in isolation, and to the exclusion of the other claims in the complaint.
Okay, so our review is de novo.
Correct.
So we read the complaint with fresh eyes, so to speak, all right? And your point is that the complaint establishes ongoing development, expenditure of time, energy, and money on the basis of this promise.
That's correct, Your Honor.
Okay. Go ahead.
Sure. And so if you look at the judge's analysis, and I'm not just suggesting, but requesting that the court does not take the similar tact of this framework of either it's the first promise or the second, but we're going to ignore the third and not consider them all together. If you look at the complaint as a whole, looking at the misrepresentation claims, that claim, it begins in May and July of 2019. And the representation was simple. Mr. Verga, Frozen 4, approached the charity. This wasn't the charity soliciting donations. Mr. Verga approached the charity, and he had a deal, a request, and that donation had strings attached. The deal was, in exchange for a donation, the charity would be listed and designated as Frozen 4's charitable support organization. That's paragraph 6 of the complaint. Paragraph 7 of the complaint explains what that means, and that means more than just sending a letter. Paragraph 7 establishes that, and this is the memorandum that Mr. Verga shared with Mr. Cook explaining the charity's role, which is, this is the plan for positive impact that that Frozen 4 was required to put together in order to get a license to open up shop in Marshfield.
Is there anything in the complaint that alleges that any of the trust programming was necessary for the defendant's PPI?
Yes, Your Honor.
Okay, where is that?
It's overall, but I want to direct your attention to,
You say overall, that's kind of...
overall, the entire story is that the entire request is in exchange for your support, which means providing programming that is necessary for the plan for positive impact. That is what the charity provided to the Frozen 4.
Are you saying that when we look at a complaint to determine whether it sufficiently alleges the claims that we do sort of an overall story analysis?
The analysis is...
I'm familiar with that approach.
The analysis, you read the complaint as a whole, and you don't read the allegations in isolation. So when I want to point to paragraph 10.
Just give me at least one.
Sure. Paragraph 9 and 10, and that's February of 2020. Mr. Verga announces to the charity several things. First, that he received the host community agreement, and second, that the Cannabis Control Commission appointed the charity, the Cook Family Charitable Fund, as Frozen 4's charitable organization. Paragraph 10 says, that's again the donation, which is $50,000 over the course, within the next couple of months, to enable the fund to continue and start programming in ADI communities in southeastern Massachusetts. That is, I'm providing this money, this donation, to enable the funding for the programming in the ADI communities, which was defined in the memorandum discussing the plan for positive impact. So the reasonable inference, and it's not a leap, it's barely even a skip, is that the reason for the donation was to put together the programming, which is a required element of the application and the continuing license.
I understand looking at the complaint as a whole, but when I jump to the individual count at paragraph 30, all that's listed there is that the fund agreed to be listed as a community support organization. And then similarly in count 2, paragraph 37, it's the exact same language. So it's almost like that was the agreement according to the specific counts. So why can't we just focus on the counts language?
Respectfully, I disagree, Your Honor, because count 1 and 2 incorporate by reference each of the paragraphs in the complaint. And paragraph 7 explains what it means by being listed as the community support organization. And it's more than sending a letter. It's following through on the obligations of providing the good work on the ground in the community that's required for the license to open up shop in Marshfield. And if there's any doubt about that, I'll direct your attention to paragraph 15 of the complaint. And this was a paragraph that the judge seemed to ignore in the analysis of both the misrepresentation and the charitable subscription. And that is, in February of 2021, Mr. Verga was approached by a PR firm on behalf of the charity with a press release that captures the entire agreement between the parties. And Mr. Verga was presented that and returned comment and didn't object to it according to the complaint, essentially implicitly endorsing the press release and the headline. And the headline is important. That again captures the deal. And again, the 15 states, the headline is, the Cook Family Charitable Fund receives $100,000 pledge from Frozen 4, semicolon, will use funds for online training to businesses and municipal departments on identifying addiction.
Are you suggesting that the complaint alleges specific programming that the trust developed and implemented in reliance on the defendant's promise, or that you don't need to do so?
What the complaint alleges is that Frozen 4 directed a type of programming for its benefit. It did not micromanage the exact type of programming, but it said, we need a charitable organization that does the good work in the community. We're not going to direct you exactly how to do that. That's what the charity does in operation.
But where in the complaint does the trust say that in reliance on that promise of $100,000 that we implemented the following programs?
So I'll direct your attention to paragraphs 26 and 27, and that's read in conjunction with paragraph 10, which is Mr. Verga's statement that says the donation I'm about to give you, $50,000 to $100,000, is to enable you to do this type of programming. And paragraphs 26 and 27 identify that the fund detrimentally relied on those commitments to provide the provide the donation. And then 27 explains exactly what the fund did: expend money at the direction of Frozen 4 to provide the strings attached to this donation, which is the community support organization, the programming, the plan for positive impact. That's what the charity followed through on. And so what this case is, it's a promise made. The charity upheld its end of the bargain. That string that was attached, provide the services required under the licensing. And in exchange, Frozen 4 was to give them $100,000. When the charity did that and Frozen 4 got the license, opened up shop in December of 2021, that's when Frozen 4 pulled the rug from under the charity and walked away from the donation. The complaint states a cause of action here and adequately and sufficiently does so. And the reason I was turning the court's attention to the error of the judge's analysis below is it was parsing this issue of factual finding. It's only the letter of support. That's not what the complaint alleges. And then if you look at only the letter of support, then either it's the one promise in 2019 or one promise in 2020, but that's not what the complaint says. It's a continuing pattern of promises made, promises broken, that are the factual basis for this lawsuit. And the judge made the same error in analysis in both applying to the misrepresentation claims as he did to the charitable subscription and contract claims. Your Honors, if there are no further questions, I rest on my briefs and request that this court take the four corners of the complaint, read it as a whole, see the story for what it is, what the allegations are, and that is there was a 2-year pattern of deceptive conduct that Mr. Verga and Frozen 4 promised a donation in exchange for the charity's support. When the charity provided that support through being listed as the community support organization and actually acting as that community support organization, bless you, that's when Frozen 4 pulled the rug out from the charity and didn't donate a single dollar to the charity. And for those reasons, we request that this court reverse the decision of the lower court and revive the complaint.
Right.
Thank you, Your Honor.
See no further questions, so thank you very much for your argument.
Good morning, Your Honor. Nicholas Delakis for Frozen 4 Corporation and Frozen 4 LLC. May it please the Court. The fund's complaint was properly dismissed for two main reasons I'd like to focus on today. First, the fund did not allege intent to induce. And second, the fund did not plead the elements necessary for charitable subscription. And I'd also like to address some of the statements made here today and in the reply brief, if I may. The fund did not plead that Frozen 4 intended to induce it to spend $80,000 of money that it did not have. The only thing that Frozen 4 ever asked the fund to do was say that the fund would take our money. Frozen 4
And what would have been the purpose for taking the money?
The purpose for taking the money, under the Cannabis Control Commission regulations at the time, said that we had to submit a plan for our positive impact plan that we could satisfy by donating money to a charity. And we had to show them that there was a charity that would take the money. So we never asked them to go out and develop programming or to use the donation in any way, and we never needed them to. Donating to them was enough. The fund's pre-existing mission statement.
That donation never took place. You're saying.
Correct. That donation.
Promising to donate was enough. Was that your point?
We're in the world of 2019, and we're dealing with the Cannabis Control Commission's regulations then. And they said very clearly, no dispute, your positive impact plan is satisfied by donating money to a charity, period.
Well, it's a little more than that particular type of charity, et cetera, right?
Well, it has to benefit
the community.
Disproportionately impacted communities, exactly. But by donating to them, you could satisfy that. Now, as we go forward in time, they changed their guidance, and they said, that's not enough anymore. You can't just do that. And that's when this wasn't going to satisfy the Cannabis Control Commission, and so that, I think, is the reason that you see Frozen 4 backing away.
Can I, and pardon my tendency to oversimplify, but just tell me where I've got it wrong. So they say, we need someone to give us a letter.
Yes.
Right? And you folks say, okay, if you give us $100,000, we'll give you a letter. And they say, great. And then they give the letter, and then you say, well, never mind.
Well, that's not exactly what...
Where do I have it wrong?
Okay.
So they did what they did. They gave the letter so that your clients could get the approval from the CCC, right?
Under the 2019 guidance, right.
And that was supposed to be, I mean, it wasn't just out of the goodness of, their charitable hearts that they did that. They expected to get something in return, presumably.
So I think what Your Honor...
Unless they're just
so
cannabis supporters.
The July 2019, there wasn't any statement about money, about how much. Okay, so there was never an agreement that you give us $100,000, we'll sign the letter.
Did your client give them anything of any value whatsoever?
Exactly.
Is the answer no?
The answer.
I'm not sure what the question
Did
is.
your clients give them anything whatsoever of any value in return for their letter?
Not that I'm aware of, no. No. So, getting back to intent to induce, we never told them they had to do anything with the money, and we never asked them to do anything with the money, and we didn't need them to do anything.
Isn't the standard of what it would be reasonable when we're talking about inducement, whether or not it would be reasonable to believe that to spend the money on the programming of which this charity is responsible for, known for, dedicated to, that would be that would be reasonably interpreted as an inducement?
A reasonable inducement.
In other words, a charity is not just going to pocket the money and pay the board of directors. The charity is going to do something with the money.
Exactly. And under the 2019 guidance, that's exactly what we were planning. We were planning that the charity would use the money to do the things that it already does, and that would benefit the disproportionately impacted communities. But our intent, as expressed in the complaint, was always that we were donating to you to satisfy the Cannabis Control Commission and get a license from them. It was never, no allegation anywhere that there was this, a freestanding, we are going to donate to you no matter what. It was always tied to a license. And when the Cannabis Control Commission said, no, you can't do that, well, that changes things.
How does that change an alleged, we'll call it an alleged promise, if you will? How does the change by the Cannabis Commission affect that? In other words, it was sort of gave you a get-home free card. You don't have to do it anymore. Is that what you're saying?
I wouldn't call it a get-home free card. If we're talking in the words of charitable subscription, the meeting of the minds just isn't alleged, and that's the key fact.
Well, would you agree that there was a meeting of the mind that some amount was going to be donated? In other words, because arguably, and again, I don't know how the panel's going to come out on this, but arguably, the exact amount was not discussed until a later period of time, right?
Correct.
But some amount was anticipated.
Some vague amount is discussed, but it's never, until very late, it's never solidified into anything that the fund could rely on to go out and make $80,000 of commitments,
Okay, so
which,
there could be an argument, you overspent too much money here. But of course, there was other information that came forward that was going to be between $50,000 and $100,000. Isn't that a separate argument than whether or not they were entitled to rely on this, what they do allege was a false representation, that the money was going to be donated to them?
well, we started talking about reasonable reliance, and so my answer to that was that if you look at the allegations of the complaint, as you move through time, you have varying amounts of money, never a very clear statement of of what specific amount until late in the game, and then when it's going to be delivered. And expressions by the fund of concern, are you really committed to this? And even after the parties start discussing a specific amount, the fund still comes back and says, we need some more commitments from you. As you move through time, though, the fund...
Counsel, you keep saying that there wasn't a definite amount, and I understand that's your position. But the complaint has an amount, and in a motion to dismiss, we have to accept the allegations as true.
Right.
So there was an amount. It was $100,000 to be given in return for that $100,000 a letter, kind of like a contract. So back to Justice Brennan's point, what are we missing here? Why isn't that good enough? Promise, reliance, done.
Okay. We're dealing with a charitable subscription. Law is different there, okay? Otherwise, every person who ever says that they're going to donate to a charity would be held to a charitable subscription. And the SJC has been absolutely clear in the King case that it's not going...
But here we have reliance on the organization. They did something in return, which puts it outside of those cases.
Well, the case law, though, is a little different.
Do you think it'd be different if I said, I'll donate $100 to your charity if you write me a letter and say, that is the best judge that ever sat in Massachusetts, and then I give you $100, and then you say, oh, never mind, we changed our minds now. That's a little different.
Not such a good judge.
Yeah, not such a good judge. Yeah, I mean, I'm being slightly tongue-in-cheek, but this is not just, I will give you a donation. This seems to me a more transactional language, certainly based on what is alleged in the complaint, that it's not just, we promise to give you a donation, it's in exchange for X. We will give you a donation.
And X is the issue. You have X being what's alleged in the complaint, which is, give us this letter. Okay, now that letter is a letter, it doesn't equal a license.
But that's not what they're saying the agreement was in the complaint, which we are bound to accept as true. The complaint says the basis for the fund to agree to be listed as a community support organization. They did that, right?
Correct.
Okay, and in exchange for that, according to the complaint, you were to donate $100,000.
No, that's not what the complaint alleges. The complaint, July 2019, the allegation is that we will make a donation of some amount to you in exchange for telling the Cannabis Control Commission that you'll take the money.
Where is that in the complaint? That's what I'll call it quid pro quo, but it's really not. Because I'm looking back, like I asked your opposing counsel, paragraph 30. And paragraph 30 is, would donate $100,000 for the basis for the fund to be agreed to be listed as a community support organization. Let's accept that as true.
Well, so I'm just going to rely on paragraph 7 of the complaint, where there's no discussion of money. And the allegations in the complaint are that there was no discussion of any specific amount until release. Paragraph 30 basis of the fund to be listed as a community support organization. Well, okay, that's inconsistent with paragraph 7, but let's put that aside. They were listed as a community support organization, but no harm flows from that, okay? Listing as a community support organization in a complaint doesn't equal going out and spending $80,000 in commitments that are not specifically alleged in the complaint about when they were made, to whom they were made. They say that you should look at the complaint in a holistic manner. If you do that and you look at all of the...
So according to the complaint, I didn't write the paragraph, but the fund spent $48,000 to get programs up and running after February 2020 in reliance on the contract. Isn't that sort of detrimental reliance?
Not in the charitable subscription context, no.
What
No.
would be then? They thought the promise was, you give us $100,000. They have a board of directors meeting and they say, hey, we're going to get $100,000. You know what? Let's take some of that money and let's hire a community support organizer. That seems to me to be reliance based on your promise to pay $100,000. What's different from what I just said, where they say they got they spent $48,000 to get programs up and running?
The reliance has to be reasonable, okay? In the charitable subscription context, the reliance always has to be reasonable. And I rely on the King case, which is cited in the in the briefing. The reliance there goes far beyond anything here. You had Dr. King.
You're saying that nobody could, no jury, no one could determine that this was reasonable
Well, first,
in order to survive a motion to dismiss.
the reasonable reliance was not argued in their opening brief, and so I stand on what I said in the brief, that that's an argument that's waived. But yes, in the charitable subscription context, the King case, Dr. King said he was going to donate his papers to Boston University. And he actually gave them some papers, and he continued to give them some papers in the SJC, and he required them to scrupulously care for those papers, okay? Based on that, the SJC said that that was either consideration or reliance. The court didn't have to say what it was one way or the other. My point is that in none of the modern cases is there anything like the vague statements made here where a charity goes out and spends $80,000 without ever telling the donor that it's going out and doing this, all right? Never told us that they were doing this, and then tries to hold us bound on reliance.
I suppose one could say one should never spend money they don't have in their hands, right? But that's, I look at that as a separate issue. Why they have to tell you exactly what they're doing with it when when that's never been a string that was attached on your part, right?
Well, again, I come back
Except for the fact that it had to be, of course, for the community, because that's the whole point.
Right. Well, again, there's no allegation in the complaint that we ever intended to induce them to do any of this.
Okay.
We never told them that, and they never told us they were going out and doing this.
All right. Okay. Well, this case presents interesting issues. Thank you both for your arguments. It was very helpful. And I'm going to say the panel has no more questions and ask you to get home safely because the weather's not so good, and we'll take the case under advisement. Thank you very much. The court will stand in recess.
All rise.